where does common law request fit in with OPRA?
Excellent question. So the question is essentially, what is the common law and how does it fit into this framework? So the common law right of access it's like OPRA in the sense that it's an independent mechanism for you to get access to records. So what does that mean? Well, when you make your request for records, you say, I want the records under OPRA. But you should also say, and sometimes the records custodians forms have a check-off box. You should also say, if you don't give me the records under OPRA, please give me the record. Well, I'm making this request pursuant to OPRA and pursuant to the common law right of access. So under OPRA, a document is either public record or it's confidential. There really isn't any, and there's exceptions to this, but there isn't discretion. Like for example, a record is either a criminal investigatory record and you don't get it, or it's not a criminal investigatory record and you do get it. That's OPRA. Now the common law right of access, that's not a black and white test. Under the common law right of access, the public agency is supposed to weigh your interest, you the requester, your interest in disclosure versus the public agency's interest in non-disclosure. So that's what the lawyers in the courts call a fact-sensitive test. It means they have to look at the particular circumstances of your request and your need for the record and then weigh that against confidentiality. So when you're making your OPRA requests, you should always make sure to also make the request pursuant to the common law right of access. Now, I believe you don't have to. My view is if you say OPRA, that's enough, and the common law, it's just, you don't have to specifically say you're making a request pursuant to the common law, because the common law is always there in the background. It exists. It's always enforceable. But if you say the common law, that just makes it more clear regarding what you're looking for. I've had some good success getting records under the common law right of access. In Warren County, we had a situation where a corrections officer was being internally investigated for using generators during Hurricane Sandy. And then the internal investigation by the sheriff got to the point where it might have been criminal. So at that point, the investigation went from the sheriff's office to the prosecutor's office. And the prosecutor's office conducted an investigation, and they closed it. We don't find any evidence beyond a reasonable doubt that anyone did anything wrong, and they referred it back to the sheriff's office for the internal affairs investigation. So my client made a request to the prosecutor's file, and he made it under OPRA and the common law right of access. And the judge said, no, you don't get it under OPRA, but the judge agreed that we do get the entire file under the common law right of access. Of course, there were some exceptions, there were some redactions, but on the whole, like for example, everyone's names were redacted. The name of the target was redacted. The name of the witnesses were redacted, which is fair generally. But the judge held that we get the entire file under the common law because our client's interest in disclosure was greater than the prosecutor's office interest in non-disclosure. So you always want to think about the common law. And then, one of the things you say about OPRA is that, well, the reason why you want the record doesn't matter. Well, that's true under OPRA, but under the common law, the reason why you want the record does matter. It helps if you're requesting information about yourself or your family or some situation involving you. It helps if you have a personal interest in the information. So, if you're making a common law request and you have a personal interest in it, a specific personal interest, you should say that. You may make it more likely that you'll get the record. Now, the case I talked about, we won at the trial court, we won at the appellate division. Now the other side has appealed to the Supreme Court, so now we have to wait. We have to wait for the Supreme Court's decision. That case, I think that case is 3 years old. So you talk about getting denied just by the waiting game. That's what I think is going on there.